The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Good afternoon or good morning. I'm Anna Hobson, the Marketing Manager at the American Chamber of Commerce Resources, as well as hrsimple. We would like to welcome you to today's webinar, Military Leave. Today's webinar will be about 60 minutes long, and at the end, we will provide SHRM and HRCI codes. Those will be put up on the screen for you. If you do have any questions, there's a question area in the chat box. We will be answering questions during the end of the presentation. If you need to go over the webinar again, it will be posted to our YouTube page, which is under the name hrsimple. Today's speaker is Trevor, and he represents employers in traditional labor law and employment law matters, with a specialized labor practice and focus on the negotiation of collective bargaining agreements, contract administration, arbitration, and representation before state and federal agencies. Trevor is actively involved with the Oregon State Bar, where he serves as the chair-elect and upcoming 2020 chair for the Military and Veterans Law section, and is a member of the Labor and Employment Law section. Before beginning his legal career, Trevor served on active duty as a captain in the U.S. Army. He has been a member of the Oregon National Guard since leaving active duty and currently serves as an attorney in the Office of the Staff Judge Advocate. So before I pass this off to Trevor, I just wanted to thank everyone for coming out and learning with us today. So on that note, I'm going to go ahead and pass this off to him.
Who is out there listening to the webinar. And so just a little bit more about my background. As Anna mentioned, before entering the legal profession, I was an active duty soldier, and I now serve in the National Guard as a JAG attorney. And so my perspective on the military leave issues that we're going to cover sort of comes from both sides, as I've been an employee utilizing these these leave protections, and I'm also an attorney who represents employers who are dealing with these issues and trying to support their employees who are members of the National Guard and reserves. And so I also spend a lot of time in my capacity as a JAG attorney in the Guard briefing soldiers on this same topic. And so a lot of the stuff that I'll cover today it isn't necessarily in the slides or in the statutes or regulations. Really what it is best practices and just things that I've seen work well for employers and also work well for their employees who are leaving from time to time to serve on military duty. And so with that, we'll get started with the slides. I know Anna mentioned there's a way for folks to submit questions. Typically, when I do these presentations in person, I like to say, if there's a question, please raise your hand, because probably someone else has the same question, and I typically go through the questions as they come up during the presentation. But with this web format, we'll consolidate all of your questions at the end, and I'm going to try to leave at least 10 to 15 minutes to answer questions at the end so that we can keep this to an hour or less. So with that, I will get started with the slides. Okay, so here's sort of an overview of what we're going to cover. The main federal statute that I think probably all of you are familiar with, at least loosely, is the Uniformed Services Employment and Reemployment Rights Act. That's kind of a mouthful, so we call it USERRA for short, which is much easier. And so there are sort of three components to USERRA. There's an anti-discrimination component, a benefits component for service members while they're away serving, and then a reemployment rights component. And I would say the third component is probably the one that raises the most questions for employers and employees alike. So we'll cover all of those. Then we're also going to cover other benefits for deployed employees. And this is something I added in. It's not necessarily within the responsibility or wheelhouse of most employers, but I like to let folks know just the other benefits that are out there for their employees who are away serving. In case those questions come up, there's some tax benefits that can be helpful for benefits folks and payroll people to know about for their deployed or returning employees. So we'll go over those. And then at the end, I just want to point you to a couple of resources for employers who are dealing with issues related to employees who are members of the National Guard or reserves. And these are resources that I myself use all the time, and I find them really helpful. So that's sort of our overview, and we'll get started. So first of all, why is USERRA important? I mean, the main reason is that we've got 435,000 or so soldiers in the National Guard in all 56 states and territories. We've got another 437,000 folks across the reserve components of the Army, Air Force, Navy, Marine Corps, and Coast Guard. And so you're looking at almost a million folks spread across all 56 states and territories who are in some way involved in the reserve component. And so there's probably a good chance that obviously if you're on this webinar, this is an issue that's come up, or you have employees who you know are members of the reserve component, but many employers don't actually know that they have an employee who's also serving in the military until an issue comes up. So just having a baseline understanding and knowledge of USERRA and the other benefits associated with the reserve component is really helpful. And the third bullet there, members of the National Guard and Reserves have been continuously deployed since September 11th, 2001. And so this is something that it's not just the active duty who is deploying. There are a lot of reserve component folks who have deployed multiple times in some cases since 2001, and there's not any indication that that's going to stop anytime soon. And so just good knowledge for employers to have. Okay, so the first component of USERRA is an anti-discrimination component. And so sort of as a threshold matter, it's important to know what type of service is protected by USERRA. And so the first big point is whether your employee who is a member of the Guard or Reserves is serving either voluntarily or involuntarily, their service is protected either way. So service in the active and reserve components, public health service, commissioned corps, and persons designated for service in national emergencies. So the first one, active and reserve components, fairly obvious. If you have an employee who's a reservist or a member of the National Guard, and they get called up on orders for an overseas deployment, they transfer on to active duty. That service is protected. And then the third bullet there at the top, person is designated for service in national emergencies. That's going to be a lot of your National Guard folks if there are natural disasters, hurricanes, tornadoes, earthquakes, forest fires, things like that. The National Guard is very often responding to those, and obviously they often happen without much warning, and so those are the times where you may have employees calling in, right before they have to be out on military leave to let you know, hey, we're responding to a forest fire and I'm going to be gone for 30 days or whatever it is. So under the statute, service means, I've sort of already covered this, active duty and training, weekend or weekday drill for the reserves and National Guard, funeral honors, and fitness for duty examinations. The funeral honors is something that the military does. There's each state and territory, typically the National Guard has a group of folks who have been trained in conducting military funerals, and a lot of times if a veteran in your state or territory passes away and has requested a military funeral, the folks in your National Guard who have been designated or who have volunteered to do that will sometimes be called up for a day or a half a day during the week to conduct those funeral honors. And then the other big one is weekend or weekday drill. Most people think about the commitment for a reservist or a National Guard member as being 1 week a month, 1 weekend a month, and then 2 weeks a year. And that's fairly standard, although with deployments, natural disasters, things like that, sometimes the commitment is more than that. And all of that is covered under USERRA. Okay, so the anti-discrimination actual provisions in USERRA that prevent employers from discriminating against employees who are engaged in any of the types of service we just covered. So, if you're an HR or a manager, you're obviously familiar with a whole host of other employment laws that prevent discrimination, and the anti-discrimination provision in USERRA is relatively similar to the ones you're probably familiar with. You can sort of think of military service in the reserve component as a protected class, like other protected classes that you're familiar with in other employment laws. So employers are not permitted to discriminate against reservists and people in the Guard in hiring, in promotion, in retention, reemployment, and other benefits of employment. And again, it's similar to the analysis in many other employment laws. It's not if a service member employee feels that he or she's been discriminated against because of their military service, they don't have to show that the adverse employment action was solely motivated by their military service. They just have to show that it was a motivating factor. So it could have been one among several reasons, but if they can show potentially that an employer at least in part decided to take an adverse action because of their military service, that meets their burden, and then the burden shifts back to an employer to show that military service or membership in the reserve component was not a motivating factor. Obviously the hope after training like this one is that you're not ever going to end up in this situation, but that's sort of the analysis. In most of the USERRA claims that I see representing employers have to do with the anti-discrimination provision, and a lot of times it's either in hiring where an applicant felt like the fact that they were a reservist was a reason that they were not selected for a position, or they're a current employee and they were passed over for promotion in favor of other folks, and they feel that their absences or their service in the military was a motivating factor in them being passed over for a promotion. And so, the advice I give employers when it comes to, employment decisions, hiring, and promotional decisions, you really just need to show your work and make sure that you can articulate all of the reasons. If you're going to promote someone who's, if it's between a service member and a non-service member, and based on the criteria that you've set, you decide that the non-service member is the more deserving employee for the promotion. Just make sure that you can show here are all the objective job-related factors that we compared these two employees on, and here's how the non-service member performed better or rated better than the service member. And that being able to show that a lot of times is sufficient to rebut the claim that military service was a motivating factor. So that's the anti-discrimination prong. Now, the second prong of USERRA is sort of a menu of benefits that are available to folks while they're away from their job, serving in the reserve component. And really, this part of USERRA, the benefits prong, I think really makes the intent behind the legislation fairly obvious. When Congress passed the original version of USERRA, it has been amended several times. The intent was, the statute actually says, part of the intent is to encourage folks to volunteer and serve in the National Guard and reserve components of the military. And so the idea behind the law really initially was, from Congress's perspective, we want to make it as easy for someone who wants to volunteer to serve in the military as a reservist. We want to make it so that they're not sacrificing a civilian career, or that they're not at a disadvantage in their civilian career because of their military service, right? The idea is to encourage folks who want to volunteer, who want to do that, to do it. And really this law is at its core aimed at ensuring that these folks can do that and not have to choose between, well, do I want to have a successful civilian career or do I want to serve in the reserve component? Ideally, they can do both, and that's sort of the intent behind this law, and the benefits while they're serving are really sort of the main way that that Congress went to achieve that, along with the reemployment rights, which we'll cover. And my experience advising employers on this is, I think, in fact, I can't think of any case in which I advised an employer and they didn't completely agree with that sentiment. And so, really, where I see issues with USERRA compliance, it's not that an employer knows what USERRA requires and says, we don't want to do that, that's too much of a burden. It's typically that they just don't know all of the ins and outs of USERRA, and once we talk about it and go through it, they're more than happy to make sure that they're in compliance. So obviously this this webinar just covers the wave tops, but I think it's the baseline level of information that I would hope every employer has about USERRA to support their military employees. So the first benefit is a seniority-based benefit, and what USERRA does is it says if an employee is serving in the military away from their civilian job, they're going to be treated like they're taking an unpaid leave of absence. What it also says is that while there's no requirement for the employer to pay the employee while they're away, of course, some employers do that, and it's certainly okay to pay employees while they're on military leave, but the USERRA doesn't require it. But what it does require is that you essentially treat them for seniority purposes like they were still there. And so one very common example is leave accrual, right? And so if a lot of employers have paid time off or vacation accrual that increases at certain thresholds depending on how long you've been with the employer. So you get a certain allotment or accrual each year until 2 years, and then it goes up at 5 and 10 and so on. In cases like that, what you need to know for military employees is if you have an employee who, let's say, your leave accrual threshold goes up at 5 years, and you have an employee who's a reservist, gets called to a deployment for a year, and he's in year 4 of his employment with you. He comes back the next year. When he comes back, his accrual rate for vacation should be calculated at the 5-year threshold, even though he was gone for a year. You're just treating it like he was there the whole time for accrual purposes, and that applies to any other seniority-based benefit. If there's a benefit that is calculated by years of service or years of employment, your military leave counts towards that. So other benefits while folks are deployed. So just as a general rule with USERRA is that employees must be given the most favorable treatment accorded to any comparable form of leave. And I've cited a case here where a court found that jury duty leave was comparable to military leave. So whatever benefits a employee was entitled to under jury duty leave, they, if it was better than what the employer was giving for military leave, they were entitled to the more favorable treatment. And so sort of the upshot of this requirement is if you've got different types of unpaid leave that folks can go on for different reasons, and the benefits or the things that you provide or allow employees to do while on unpaid leave, as far as USERRA is concerned, you have to treat the military leave like you treat other unpaid leaves if the benefits associated with those leaves are better than what you offer for military leave. So a more direct way of saying that is your military leave should be as good or better than any other type of unpaid leave that you provide. So part of that is health plans, and there's some actual carve-outs in USERRA related to employer-provided health plans or health insurance. So if you have health insurance that you apply or offer to your employees when a employee service member leaves on military leave, they're still entitled to be covered under your group plan for the duration of their protected leave under USERRA. And so they can elect, and if they're gone for up to 2 years, they can elect to continue coverage for that period of time. The big question that comes up is that if you've, while they're employed, if you've got a premium split, maybe you're paying 85% and the employee share is 15%. While they're gone on USERRA leave, you're not responsible for continuing to pay the employer portion of the premium, but you do still have to offer the plan if the employee wants to stay on the plan. They'd just be responsible for 100% of the premium costs. Now, the caveat to that is if their service is 30 days or less, and there's a cost share for the premiums, you're still responsible for paying your employer share during that time. So it's just anything over 30 days. So a common example of this is National Guard soldier has her 2-week annual training, let's say in July, and is gone for the second 2 weeks of July, on unpaid leave, but she's also enrolled in your employer provided health plan, and you've got a premium split there. Even though she's on unpaid leave for those 2 weeks in July, you're still responsible for covering your portion of the premium for that whole month. So that's sort of the breakdown. Anything over 30 days, if they're on unpaid leave, the employer is not responsible for covering their share of the premium. Now, with all of these protections, right? This is the baseline. There's no restriction on providing something that's better. So some employers, I have seen some employers who will continue to pay the employer portion of the premium while their employee is on USERRA leave, even if it's unpaid leave. That can be pretty costly, but some employers do that, and that's certainly an option, but you don't have to. Also, I think it's worth mentioning here that when reservists are deployed or put onto active duty for any time beyond a month, right, the 30-day threshold, they're eligible to be enrolled in the military's insurance, which is called TRICARE, and that covers their whole family. And TRICARE is actually very good insurance. And so you don't necessarily have to worry if we're not paying our part of the premium while someone's gone for a long period of time, is their family not going to have insurance? When they're called onto active duty, they have access to TRICARE, which is good coverage. So there isn't necessarily a concern about them not being covered, but many employees have health plans that cover things that TRICARE won't, or they have a doctor maybe for their family while they're away that isn't covered by TRICARE. And so there are a lot of reasons why folks sometimes choose to stay on an employer health plan while they're gone. But it's just good for employers to know that they do have access to health care through the military when they're on extended leaves of absence from work. Okay, so that covers the benefits portion of USERRA, and now we'll get into the reemployment rights section, which I think I probably get the most questions from both employers and from members of the military in my JAG capacity. This part of USERRA is the one that I think comes up the most because a lot of times folks don't really think about this stuff on the front end of their deployment or their activation or potentially if it's a natural disaster or something like that. They don't have time to think about it because it's unexpected, and then you'll get to an end of a deployment or at the end of a period on active duty for something, and all these questions come up on both the employer and employee side. So this information is great to have at your fingertips before people go and then as they're preparing to come back. Okay, so what are the reemployment rights under USERRA? So you have reemployment rights as a member of the reserve component. If you're absent due to military service, And then there's sort of 4 basic requirements that the employee has to meet in order to have their reemployment rights under USERRA. So the first one, and we'll talk a little bit more about it, it comes up fairly frequently, is the employee is required to give notice in advance of their service. And we'll come back to that one. They obviously have to perform qualifying service, which means any of the categories that we went over at the beginning, and as part of weekend drill, annual training, or some kind of mobilization, deployment, or activation onto active duty service. They have to receive an honorable characterization of service. And for the reserve component folks, the way it works is essentially every time they come back off of an active duty tour into their reserve status, they're released from active duty, and they actually get a document that says that's similar to what someone who is on active duty would get when they leave for good. But it basically characterizes their service as, typically it's honorable, but if their service is characterized as other than honorable or dishonorable, then they don't necessarily have these reemployment rights. That doesn't come up very often, and most folks aren't inquiring about it, but it is one of the requirements to have USERRA reemployment rights. And then they have to timely request reemployment after their return from military service, and we'll talk about that in some subsequent slides. The amount of time that they have after they finish their tour of duty, the amount of time that they have to request reemployment depends on how long they were gone. So we'll go over that. But I want to go back to the first bullet. So giving notice in advance of service is a requirement. What's not required under the statute and regulations is it doesn't have to be documentary. So they don't, if you have an employee comes in and says, hey, next month my National Guard unit is deploying to Afghanistan, and we're going to leave on or about December 15th. That they've met their requirement to give you notice. It only has to be verbal, and in fact you're not actually allowed to say I want you to show me your deployment orders, or I want a memo from your commander, or anything like that. You can actually ask for that on the back end when they come back to verify that they've requested their reemployment in the requisite amount of time afterwards. But on the front end, you can't actually request that. However, every chance I get when I'm briefing soldiers in my JAG capacity, I tell everyone, hey, when you find out that you're deploying and you get orders or you get a memo from your commander, give that to your employer. There's really no good reason not to provide your employer with a copy of your orders or with a memo from your commander or whatever documentary proof that you have of your upcoming deployment. So that's what I tell soldiers, and I would hope that most folks are doing that. And I tell them that protects them too, because then that goes in their personnel file, and there's no question about whether they gave notice or when they left or when they're going to return. Sometimes that does change from what's on the orders, but the bottom line is there's almost no instance when, if you have the documents, it's not a good idea to give it to your employer. And so that's the advice that I can tell you that the reserve components are giving to soldiers. Hey, give your employer as much information as you can to help them support you. But under the law, you can't ask for it on the front end. So timely requests for reemployment. And this is where employees and employers sometimes get tripped up. So here are the thresholds, and this is a great slide to have at your fingertips if you're an HR or payroll or a manager, so you can reference this when folks are coming back. So if their service is less than 30 days, so that's going to be typically an annual, a 2-week annual training, maybe a 3-week annual training, their weekend drill duty. Sometimes they have, sometimes the National Guard will have drill weekends where they drill Friday, Saturday, Sunday, Monday. So maybe that's, they're coming back on Tuesday. But anything less than 30 days, the request for reemployment needs to be the first scheduled work period 8 hours after they come off of duty. The practical implication of this requirement and the way it works is that this isn't so much a request for reemployment. If they've told you, hey, I've got drill on Friday and Monday, okay, so your next schedule, if they're working a Monday through Friday job, their next scheduled shift will be Tuesday, right? And the only place that there's some, if they come off of orders, let's say, if they come off of duty at 9 p.m. on Monday, and they have a shift where let's say they start at, their shift starts at, they're working like a graveyard type shift, and their shift would actually start maybe at midnight or 2 a.m. You would need to adjust their shift that next work period, or potentially just give them that next day off and have them start maybe on Wednesday if they don't have the 8 hours between when they return and when their shift would start. But this first threshold, the less than 30 days, it's really not, formally it's a request for reemployment, but really what you're doing is you're just working out scheduling so you know when they're going to be gone and then when their next shift after they come back should start. So then your next threshold is 31 to 180 days. So these are typically your longer term, usually planned deployments, but again, sometimes folks can be called up unexpectedly, especially in the National Guard for natural disasters, and those orders can sometimes last longer than a month. The big one was Hurricane Katrina. There were National Guard folks from I think over 30 states that actually responded and went down to Louisiana to support the Louisiana National Guard, and some of those folks were down there for over 60 days. And so sometimes you may have an unexpected absence that's longer than 30 days. More typically, those are planned deployments, and you're going to know about them pretty far in advance. But for any of those, so 31 to 180 days, the employee has up to 14 days to request their position back. And again, just sort of flipping over to what I can tell employers that the military is advising soldiers and their employees. The military is telling those folks, hey, give your employer as much information as you can before you even come off of orders. Don't wait till day 14 to call in and say, hey, I want my job back. Right? Give the employer as much lead time as possible so that they can work you back into things, make sure that you have a smooth transition back into your civilian position. But the law says they can take up to 14 days after they've come back. Again, on the back end, as I mentioned, you can request orders. You can request documentary proof of when they returned if there is some question about whether they requested their job back in the right amount of time. So you can do that on the back end, but hopefully that's not a problem, and they've kept you in the loop. And then anything over 6 months, so 181 days or more of service, they get 90 days after they return to request reemployment. And they don't, so again, we tell folks, don't wait till day 89 to call your employer and let them know you're back. Give them as much information as you can so that they can set you up for success on the way back. Okay, so the escalator principle. Again, this outside of the reemployment request, this comes up quite a bit. And the escalator principle is something that USERRA has, or it essentially says, and this goes back to Congress's intent with this law, which was we don't want folks to have to choose between a rewarding civilian career and a rewarding career in the reserves. We want them to be able to do both without suffering in their civilian job. And so when determining the position for reemployment, employers must apply the escalator principle. And what that means is they have to look at where the employee would have been had he or she remained continuously employed, including any automatic promotions or incentives that they would have received had they been there the whole time. And the escalator principle it's an inexact science in a lot of jobs because it's in jobs where the promotion process is pretty lockstep and pay increases are pretty lockstep. You can just look at, okay, what is the if you've got a union contract, usually that has everything that has everything you would need to know about how should this person be treated when they come back, what incentives have they have gotten, what if you've got a step system where step 1 through 10 and it's determined by time of service, you just apply that like they were there the whole time. That's pretty easy. It's a little bit trickier maybe when you don't have a union contract, maybe you don't have personnel rules which are really explicit about these things, but you're just you're just evaluating employees individually or in groups, and their benefits increase sort of on an unplanned schedule, and it's just as things go, you assess people. In those cases, just be very careful about, hey, is this person, are there other folks that had a similar or the same job while the service member was away? How were they treated? Usually the safe approach is to just apply what you did for those other folks to the person coming back. And if you have questions about this, should I or shouldn't I, or do I need to do this to be in compliance with the escalator principle, check in with your HR folks or your labor and employment counsel to get advice on that. One caveat to this is the escalator principle doesn't protect folks from reductions in force. And that would be if someone was on USERRA leave and their position was eliminated because of a company-wide restructuring, right? If the position was eliminated, that can go through. It's not prohibited by USERRA. And then an issue that sometimes comes up, especially when folks are returning from deployments, there's a sort of an extra layer of consideration if they come back with some kind of injury or disability. And all of the things that you would do under the ADA to reasonably accommodate someone, you still have to do all of that. But what constitutes a disability connected to military service is defined broader than what it would be under the ADA. And so if those types of issues come up when your employees return, I would encourage you to again, check in with your local counsel to make sure that you're accommodating anything that might be considered a disability due to military service. Okay, so then sort of the last component here of USERRA is a protection against discharge, and this really kind of goes to the anti-discrimination piece. And so what the statute says is that a reemployed employee under USERRA can't be discharged except for cause. And we'll come back to that. But the protected, there's thresholds on the discharge protection as well. So anything service 30 to 180 days, they have that protection for 6 months, and then anything over 180 days, they've got it for a year. Now, this protection is aimed at preventing employers from complying with the reemployment provision because they feel like they're required to, and they are under the federal statute. And then right after that, getting rid of the employee because maybe they replaced that employee's position while the employee was gone. They reemploy them to check the box on USERRA, and then 3 weeks later they say, oh, well, we actually filled your position while you're gone, so we're gonna, you're gonna be laid off or lose your job. So it protects against things like that for 6 months or a year. It does not, and this is, I think, sometimes a misconception among some employees, it doesn't mean that you can't fire someone for cause or terminate someone for cause during that period. So if someone comes back, they've been reemployed under USERRA, and they commit misconduct that you would fire anyone else for, then by all means you should go through with that. That would be a for-cause discharge. But again, because of this statutory protection, you really need to be very meticulous and show your work so that if you end up with a complaint after you've terminated someone for cause, you can show that this had nothing to do with your return from military service. It was because you violated X, Y, or Z policy. Okay, so that wraps up the USERRA portion of this, and we're about at 50 minutes, and I want to make sure that we leave time at the end for questions on the USERRA stuff. So I'll go through these next couple slides fairly quickly. Like I mentioned at the beginning, these are not necessarily the responsibility of employers, but these are benefits available to service members because of their military service and because of their deployments on active duty that they're entitled to. And I find it's helpful just for employers to be generally aware of these things to help their employees or if questions come up. So the first one is the Service Member Civil Relief Act, SCRA for short, easier to say. So these are just some of the basic benefits that your service member employees are entitled to under this law. 6% interest rate on all debt incurred before deployment. So that applies to credit cards, any other type of consumer debt, any kind of loan that carries an interest rate while they're on active duty for a deployment. The SCRA requires that the interest rate, if it's over 6%, be lowered to 6% for the duration. And most lenders and banks, credit card companies are very familiar with this law, and typically all it requires is someone to call in and say, hey, I'm deploying, will you give me the SCRA rate? And they'll usually do it just over the phone. If there are any legal proceedings while the employee is deployed, and this sometimes comes up if there are employment-related legal proceedings that involve the deployed employee. Under the SCRA, they are entitled to a stay of proceedings until they return, but they do need to notify the court of their status on deployment. The SCRA also protects folks from foreclosure during deployment and for up to a year after, depending on how long they were deployed. And then finally, if they have some kind of default or judgment against them while they're deployed and they weren't able to respond because of their deployment, the SCRA has a provision that allows them to to go back and reopen the case and get the judgment reversed. Tax benefits, this may be relevant to anyone who's in the benefits or payroll realm. So just filing, anyone who's deployed, when you're deployed, you automatically get a 6-month extension from your return off of orders, and there's no need for the employee or the soldier to notify the IRS. Just when they file their taxes, they need to attach a copy of their orders. And then tax exemption, any income earned while in a combat zone is not taxed by the federal government. And that also applies if a service member is injured, comes back to U.S. and is hospitalized due to that injury. During that hospitalization, they're not taxed on any income by the federal government. And then many states don't charge or don't tax income earned outside of the state while on military orders. I'm in Oregon. Oregon is one of those states, and I know that there's many others, but if those questions come up, I would refer folks to your to your state's Department of Revenue website to look that up. Okay, so the last part I'm going to hit and then open it up for questions are a couple of resources that are designed to help civilian employers navigate all of the issues associated with deploying service members, and they're resources that I myself use all the time. So the first one, and many of you may be familiar with at least this first one already. So the first one is Employer Support for the Guard and Reserve, ESGR. It's a DoD program, Department of Defense, that promotes cooperation and understanding between the reserve component, its service members, and civilian employers. And really the biggest component of the ESGR is there are a ton of resources for employers of folks who are in the reserve component. And so there's a link to their website there. And I would encourage anyone who's not familiar with the ESGR, when you have time after this, to log on to their website and just poke around and see what they have to offer for employers. And there's they even have technical assistance, right? So, and it's free. So if a strange USERRA or SCRA question comes up, or anything related to military duty, there's I think you can submit questions online, and there's also a phone number that you can call, and they can help you through those issues. Also, there are ESGR offices and liaisons in every state and territory, so you can log on and find the point of contact in your state and reach out to them if you have issues. And then the other really kind of cool thing that they have is they have awards and incentive programs for civilian employers who do a good job supporting their employees who are in the Guard and Reserves. And so there's some neat benefits there. So ESGR is great for employers. I use it as well. And then the last one is, this is a resource that's fairly new to me, but it is a fantastic database. It's a state veteran benefit finder, and I put the link there. It was actually created by a defense think tank in Washington, D.C., but that link will take you to sort of a search page, and then you can search for all of the benefits. And it's not just veterans benefits. What you can do is you can look up your state, and it will give you a list of every benefit that is available at the state level for current service members and veterans. And that includes employment protections, something we didn't cover today. A lot of states have a veterans preference law where if you're applying for public employment and you were a veteran or service member, you get a preference. Anything like that, it's a comprehensive database. And so if you're not sure about, does my state have this, or what are my obligations, or what benefits do my employees maybe have available that they're not taking advantage of. Those should all be there. So that's a great resource that I highly recommend. So with that, I will open it up for questions.
Perfect. Our first question is, so my current policy says we pay full-time employees for their jury duty. I must pay the employee who went on leave for the National Guard for 3 weeks as well?
Potentially, we'd have to look at your policy, but I think, well, if you're paying folks across the board, that would be paid leave. So I think you're probably okay there. What the law says is that however you're treating unpaid leave in other areas, you have to treat USERRA that way. So if jury duty is paid, that would be okay. If you're paying someone while they're on jury duty, that doesn't mean you have to pay them while they're on USERRA leave. I think where it would potentially be an issue is if jury duty was unpaid, but there was some other, fringe benefit they still got while they were on jury duty, but you didn't get under USERRA leave. So you're kind of, the threshold of the analysis is this an unpaid type of leave or a paid type of leave?
Okay, our second question is, does the escalator apply to promotional opportunities that occurred while the person was on military duty for which the employee would have been eligible?
Yes. And so if it was, and again, a lot of these are very fact specific, it doesn't mean that you have to consider them, but if they want to apply for it, they have to be, you should let them apply for it and then go through the same process you would otherwise. But you don't necessarily have to promote them just because they're on protected leave. So that's how I would answer that. They need to be able to, they need to have the ability to be considered, but there's no obligation to actually promote them if it's a process where you're considering other folks. So that's how I'd answer that.
Okay, and our last question is, how long is the period of military duty at the end of which the person has reemployment rights?
How long? So I think, is this question I think is asking what is the maximum amount of protected time on it?
Yes,
is that how you understand? Right. So it's, and I probably should have included this in one of the slides. It's 5 years, and so that a lot of folks are actually surprised that it's that long. So someone that has USERRA rights for up to 5 years while they're on active duty military service. If they go longer than 5 years, they're not protected by USERRA anymore. So that's the max.
Okay, and that's all of our questions for today.
Okay, great. Well, thanks to everyone for tuning in, and I hope this was beneficial. I hope the slides are helpful. I know that there are folks from all over who are on this webinar, but if there are questions, whether you're in Oregon or not, this last slide has my contact info. I'm happy to answer questions if people want to reach out. But again, thanks for the opportunity, and thank you all for tuning in.
Thank you, Trevor, for taking the time to present the webinar. We would greatly appreciate it.
Thank you.
Okay, so at this time, I have the Sherman